So the situation basically came to our attention in October 2018, September actually, when I made contact with my son just on the spur of the moment, and I ended up taking him to breakfast, and he opened up and said that his marriage was on the rocks, that he was leaving his wife. She'd basically driven him out, and he had nowhere to go. So of course you step in as a father and you say, how can you help? And he then unloaded everything that occurred over the past period with him, and I said, fine, let's what do you want to do about that? And a week later he decided to he came and stayed with us, and he decided he had a vehicle with him. He decided to drop it off at her place because she had no transport. He always looks at how it's affecting her and the kids, and he was still very much in that, what have I done, should I be looking after her story. But so he left the vehicle for her and then jumped in my car and came to our place and lived there for the next period of time, well up probably 4 months, 5 months. They were living together, and he then decided that the separation had to happen from the September the 1st, and that he would need to go out of the house because they were fighting a lot in front of the children, and his main concern was that this would negatively affect the children because the fights were quite bad. Not physical, but there was a lot of verbal toing and froing between the two. She's a very strong woman, and she doesn't hold back with anything that she can tell him, and so she and he decided that, well, she threw him out. Basically, she said, well, you're not going to sleep here anymore, and in fact the only place you can sleep is in the dog bat. And so, you know, basically he said, it's untenable, I've got to leave. So he did decide to leave, and for the sake of the children. He told us that a number of times, that yes, it wouldn't be a good place for the children. They were in a very small home, sharing bedrooms. Yeah. No, he had no space for himself. Mm-hmm. And so when he was thrown out of the bedroom, basically, he was going to have to sleep on the couch or somewhere else, find a place she wouldn't let him.
You know, prior to this, my son said to me the only reason he did stay as long as he stayed was for the sake of the children. He had always put his children first, and he thought, better be in an unhappy marriage, but at least my children have a father and mother figure at home. But when it escalated to the point of her throwing things at him and being verbally abusive in front of the children, using incredibly bad language, he knew that he did not want his 3 children to grow up in an acrimonious setting like that, and that's when he decided he would leave.
There was a fairly quick application for the family court because obviously she wouldn't let him see the kids, so he needed to apply through channels to get access to the children, and it was quite a while before we found a lawyer. There was this, can we fix it in mediation? The mediation bit came along. She didn't want to play with the mediator. She didn't like the mediator that he had. She accused the mediator of being biased. A lot of things like that. So mediation just didn't work. So he decided that he would have to find a lawyer, which was something we had always said, look, if you get away without a lawyer, great, because they are expensive. So we found a family lawyer for him, a family law lawyer, and he's taken on the case, and has been quite expensive to everybody involved. The whole family's had to chip in with the financials, and of course during that time, just at that same time, there was a major financial commitment being made by the wife in purchasing a home in Subiaco, and this was really an added catalyst that she went ahead and bought this place. It was her decision to buy this house, and the house is totally unsuitable for the children. It's on a major road. The first thing that can happen is the child walks out the gate and gets flattened by a car. So at the purchase of the house, I actually went and fixed the gates and stuff like that, trying to do things for them to make the home livable, but it was not going to last. So he that wouldn't have made it easy for him because he had to commit to a lot of payment which he couldn't afford. So that added extra stress, financial stress as well as emotional stress to him. And of course that shows up in many ways, in him losing focus at work, not being able to take on all the contract work which was supporting the purchase of the house, and he ended up working in one role only because that's all he can do in terms of the time. What happens then is that the family law court was initiated. They had a come to court day. Of course, it took a long time to get there because they're busy, and they scheduled the proceedings at whatever calendar they have, when there's a suitable slot. So without regard to how it impacts the applicant or the proponent, which is a bad fact, and see his children. It was almost 5 months before he got a chance to go to the family court. So it was painfully obvious, and the judge ruled against him because he had actually made a mistake. And that cost him extremely a lot of money and a lot of time.
When my husband says he made a mistake in his financials. He actually put down on his statement,
on the affidavit,
that he was earning more than he actually was. So obviously the judge went on the paperwork that was presented to him, and
his additions were wrong. All the paperwork stacked up, but he didn't add it up.
He didn't add up.
Double check it. So the judge goes, well, there's the bottom line number. You're telling me you can't afford this, because the applicant was making an application for not just child support, but also spousal maintenance, payment of all fees and everything like that, including rates and mortgage. So a lot of money, twice as much as he actually was earning. But because he was extremely nervous, he didn't double check the figures. And this was already in the court, in his affidavit. And the judge had no choice but to go by the number that was on the page. And he didn't bother to check further because they don't look in detail. They just look at the last page and go, oh, well, there you go. So that really set him back a lot and took away a lot of his confidence. So at that point in time, we found a lawyer. And cut a long story short, obviously the lawyer did his thing and it went to court, and the mistake was obviously pointed out, and the judge accepted it. He said, yep, there was clearly, yes, there is a mistake here. What is he earning? And they had all the evidence that as to what he was earning. And the judge ruled that there was no spatial maintenance. He couldn't afford the mortgage. Clearly, he can just pay his child support.
After the judge ruled that my son could not afford the mortgage, this is where I think the family court seems to fail again, because she had the ability to go back with the same argument, trying to get him to pay the mortgage with a new lawyer, funded by her parents, with a new lawyer. But again, the same thing was presented for the third time. And that's what I don't understand.
Well, it's now been presented 3 times,
yes,
based on the same evidence. There was one instance when the application that was made to the court was late because the lawyer, his lawyer, actually did not make the timeline properly. However, there was no difference in the new application and the old one, and so the judge, to his credit, ruled that they would go by the numbers of the old one, ruled the same way, that he can't afford it. However, he said the lady is allowed to apply as many times as she wants, and so this is just goes on. And so yet again, there is a request that this whole scenario, his earnings and everything like that, will be presented to the court yet again for a 4th time, to have a look at the same numbers, because nothing has changed. He's in the public service, and as you know, they haven't given anybody a raise. So bang, he's got to present the same evidence again, but it's not until maybe May this year, and she has to also provide documentation, but she doesn't. This is the interesting thing. It's like every time she is required to present something, it doesn't happen. She just ignores it. Timelines go past. The family court has ruled that she needs to present an affidavit for including a full disclosure of her finances, her ability to find work, everything she's done, and she's indicated that she wants to work and has worked on a part-time basis. None of that evidence is being presented through Ben's lawyers to the court. And I just don't understand how come it has to present everything in multiple at multiple times the same evidence, yet the applicant doesn't have to do the same thing. It's just somehow there is a disconnect right there in our minds. Somebody can clear it up one day, but it just doesn't seem fair. And of course the judge did make the ruling when he finally accepted that have all these other things that she could get off him. And the CSA, he's not worried about the CSA. He'll pay whatever proportion is legally garnished from his salary. He's happy to pay. He doesn't want to starve the kids or do anything bad to the kids because he wants to see his kids. No, I'm not paying fees. I haven't agreed to these children. It's a joint decision to send kids to school. So why are they still at the school when there's a perfectly good public school 600 metres down the road from their house that they could walk to? And there isn't a problem with public schools unless somebody can tell me there is. But there isn't, and this is a highly recommended school, local public school. So he has to pay for this school, but he hasn't because he can't afford it. And yet this is still in the system. So the CSA thinks that he should be paying for the school. So every time that the school wants some fees, CSA thinks he's walking away from paying fees. So the CSA seems to be completely disparate from what the family court does in how they basically enforce the rules or whether they interpret the rules to suit themselves. I understand it's for the benefit of children, great, but the schools are both good schools. There is no reason for having them 30 kilometres away versus 600 metres away. Not only that, but that road that they have to drive to the school, it's actually dangerous to the kids. It's a highly contested highway in Perth where there is peak hour traffic at the time she takes them to school and when she takes them back. And she's in a small car 4 times a day with these children. We feel that that is detrimental to the children's safety, very much so. Not only that, but the car that she uses, which was in his name, has been deregistered, and because she wasn't paying any of the fees, paying none of the parking fines or anything like that. And she's putting the kids at risk by driving that car until she gets caught with it. So there's a real problem in here that the law doesn't catch up, and the family law doesn't really provide for the safety of the children.
He has informed the police that the car is deregistered and unlicensed and of course uninsured. So this person is driving around with 3 children and has been for the last 4 or 5 months in an unregistered, uninsured car. So if they should have an accident, there is no third-party insurance which will cover those children.
And the point here is that there are a number of glaring gaps in how the family court and the CSA looks, and even looks at these cases, because there has been an even more complicating layer, which was that at one point in time, we and I've always had to be in the pickups and drop-offs, were late because of heavy traffic. There was a phone call at the time when she was still talking on the phone. You're late. What have you done? You've kidnapped my children. So a false allegation was thrown out there that kidnapping the children. She must have read this in some magazine or in her school tutorials. Then he gets there, and of course the police are waiting. And why are you late? Well, there was traffic. Hello, this is Perth. Have you not seen the traffic, right? So
it was 5 minutes.
It wasn't a long time. But there was a lot of accusations about him taking the kids to our place and hiding them and having them overnight and kidnapping them and making all sorts of allegations about us as being not fit as grandparents, yet we have 2 perfectly good sons, lots of other grandchildren, and my wife's a teacher. She's well schooled in in the lower schools. I've been a leader in the community. I'm a leader in my profession. There's never been any doubt in terms of our capacity to look after children. So, but this is one of the big narratives that's going on, that we are not capable or suitable to be looked after, or even to be there to pick up the children during the time that Ben is supposed to have them by the family court. That's another gap in the family court orders, is that when you do make an order, great, it doesn't specify who can pick them up. There's still the opportunity for the applicant to decide who can pick them up in the other guy's time.
So we, on one occasion, went without our son to pick up the children, because
at his request.
At his request, because he had night shift, he could not pick them up until he couldn't get there till 8 o'clock. We were there at 6 o'clock. She made us wait for 2 hours in the car. After about an hour and a half, she came out and she said, "You're not getting the children." And my husband explained to her my son was going to refuse and said, "I want your car off my property," which it wasn't. We were parked in front of her property, but just to stop her yelling and screaming and upsetting our grandchildren in the house, we moved the car down. So for 2 hours we sat in the car. Now, as grandparents, we surely had a right on behalf of our son to pick up those children.
He asked us.
He asked us to. And this is where the system falls down. I don't believe that she should be allowed to determine who picks, if it's his own parents, we should be allowed to pick up the children.